Hi, good morning. My name is Marina Fadlon, and I'm a civil rights advocate from Maricopa County. I need to provide public notice to the Board of Supervisors. This is in accordance with the USCS Rules of Civil Procedures, as well as Rule 17 and Rule 20 of the United States Supreme Court. The Constitution of the United States of America is the overarching requirements that every state must follow. States cannot enact their own alternative legislation and substitute it for the guarantees of the Constitution of the United States. That would mean that the state laws are more powerful than the Constitution. Clause 1 of Amendment 5 to the United States Constitution says no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment by a grand jury. However, the state of Arizona enacted its own alternative legislation that permits the prosecuting attorney and police officers to charge by way of information, not by indictment as required by law. That is unconstitutional. An emolument violation is when you pay a public official to break the law. The Constitution has two areas that enforce this. Article 1, Section 10 says that no state shall create any law that shall impair the obligation of contracts. Police officers, prosecutors, judges are all under a contract to perform that is based upon the oath or affirmation that they took. The contract parameters are defined within the Constitution of the United States, and when a state enacts an inferior law that directs their agents to disobey the Constitution of the United States, that is a violation of Article 1, Section 10. The 14th Amendment is the other place that you'll find the reinforcement of the issue, and that is where it says that no state shall create or enforce any law that shall abridge the privileges or immunities of United States citizens. I'm also a victim of domestic abuse. However, the abuse I have endured during family court, facilitated by my ex-husband and Judge Melissa Zabor, has been far worse than what I experienced during my 10 years relationship. Thank you.
Thank you. Madam Clerk.
Tanawa Downing, Jessica Saxton, and Marissa Hamilton.
Good morning. My name is Tanawa Downing, and I'm the civil rights litigator that Ms. Fadlon was just leading into. So I want to provide a little bit of clarification so we can understand what was just said and what we're actually asking from all of you. When your prosecuting attorneys decide to rely upon an inferior state statute that permits them or directs them to charge by way of information as opposed to indictment as required by the Constitution of the United States of America, they are abusing the discretionary authority with which they're invested in law. Now, they're also committing multiple crimes. The first crime is Title 18 U.S.C. subsection 242, which is deprivation of rights under color of law. The second crime is Title 18 U.S.C. subsection 241, which is conspiracy to deprive of rights. Now, the laws of criminal conspiracy with regard to public officials, all of you, it states that any person who, having knowledge of any of the wrongs conspired to be done and who have the power to prevent or aid in the prevention of commission of the same, neglects or refuses to do so, may be held as defendants in the action. So upon having been provided with this notice, letting you know that your agents, the Sheriff's Department, the prosecutors, are acting unconstitutionally by relying upon an inferior state statute to abridge the obligations they have codified in the Constitution of the United States of America. I ask you guys, please, let's work together to fix this problem, because the alternative is that I will have to convert about 80,000 criminal affidavits into criminal complaints. I don't want to do that. You guys don't want me to do that. And we're not trying to get you into trouble, but you need to be made aware that if you're paying people to abridge their constitutional obligations, that is a crime. It's an emolument violation, and it is illegal. And so I know that you're going to go into your nasty attorney as soon as we're done, whether or not what I'm saying is true, and that attorney's going to point you to a case from 1884 called Hurtado versus California. And before you choose to rely upon that as the foundation, I must remind you that the Constitution of the United States of America is the foundation, not a judge-made ruling. The Supreme Court of the United States has no constituted authority to be able to alter, amend, or destroy any of the provisions or guarantees of the Constitution, because that must be done by an authentic act of people in accordance with the special amending procedure of Article 5. Furthermore, judges cannot legislate from the bench. We know that because Clause 1, Article 1 says all legislative power is vested in Congress of the United States. So I implore you guys, please step up, discharge the duties of your office, fulfill the obligations and promises that you made to the people of the state of Arizona, and let's choose to protect, defend, and preserve the Constitution of the United States of America. Thank you guys so much.
Thank you, sir. Madam Clerk.
Jessica Saxton, Marissa Hamilton, Leslie Shepard.
Good morning. My name is